Well, Aiden Fucci's family doesn't think he's a lost cause, but the only thing that matters is what does the judge think? This kid is facing life in prison, or he might get cut a break and get a chance of getting out. This is all for the 114 stab wounds he inflicted on 13-year-old Tristyn Bailey. What's going to happen next is really interesting. Well, hello everybody, and welcome to Profiling Evil in this special coverage on the sentencing of Aiden Fucci, that 14-year-old, now older, teenager that stabbed Tristyn Bailey, a 13-year-old student, 114 times in a brutal slaying in Florida. Thankfully, earlier this month, he pled guilty in the trial that could have gone on for a long time and really terrorized the family as they had to relive everything that happened in those final moments of Tristyn's life. There's been a lot of video online showing things happening in the interview room with Fucci's parents, things that happened in the police car with his Snapchat videos and other kinds of things. But the case is over, and it's time for sentencing. Hey, I hope you'll take a moment, hit that like and subscribe button, and ring the bell. I'm coming to you from Washington, D.C., and if you look over my shoulder in the distance, you'll see the U.S. Capitol. It's really nice to be here, but I'm looking forward to getting home. Now, first and foremost, the judge has to make a decision after seeing all of the evidence, hearing the confession of guilt, and then hearing earlier this week the family members in their victim testimony statements where they got on and they talked about how this kid has impacted their lives. I joined Julie Grant with Court TV this morning to talk about the case preparatory to the sentencing phase. Let's take a moment and go back and look at some of the things that family members said about this kid that they don't want to see ever get from behind bars.
I remember the vivid feelings of my body collapsing on the ground as the police informed us that they had found a body. I was the one who had to pick her up from the funeral home and make that long drive home with her ashes. I have what remains of her beautiful blonde hair, now stained red, sitting in my house, haunting me daily. I have had to become the safe place for my parents and hold space for their feelings. I would like to add my own stone to the 114 that I added for Tristyn. This white stone represents my trust in people, which died the day that Aiden Fucci chose to kill my sister.
But had I slept on that couch that was within earshot of our front door, there's a possibility my little sister could still be alive today. I have lived with that question, that weight, and that guilt since I went to wake up Tristyn on Mother's Day and found her room empty. I add this stone for the hope and belief I had in people being good that died the day that Aiden Fucci murdered my sister.
His apology was a waste of oxygen and meant nothing. It was cold, it was callous, and it was disheartening, and it left my family feeling absolutely tormented. In Tristyn's name, I will fight till the end to make sure my children, my siblings, my family, and our community will never see Aiden Fucci in society again. This white stone represents my loss in faith in our school systems to keep violent children away from the innocent.
In the hour it took me to drive to Tristyn's home, I had convinced myself I would arrive to see her being lectured by her parents. Instead, I arrived to a war zone. Police cars, a helicopter circling overhead, bloodhounds searching, and dozens of people from the community trying to find Tristyn. Not only is she not here, she was ripped from us with utter malice and evil in the most hideous way possible. This white stone represents the loss and happiness and emotional stability for me and my family, which died on the day this defendant chose to murder our granddaughter.
February 6th, you finally admitted to your guilt in murdering my daughter, Tristyn, after you clearly sat in this room and agreed to all of the questions and statements that were read by the judge. and admitted that you knew what you were pleading to. At the end of that, you turned around, or you didn't even turn around, you made an apology. I want to be clear, saying that your insincere apology is not accepted. And this rock represents the loss to our family and the world for all of the good Tristyn would have done.
Well, that was one of the first questions out of Julie's mouth, is what I think is going to be the pressure placed on the judge. I mean, this kid could get life in prison, or he could get a reduced sentence, as little as 25 years, and then have a chance at rehabilitation. 25 years only makes him 40 years old. Gives him a lot of life to live after that. And that's the question. Should he be given that opportunity because he killed a girl, stabbed her 114 times? I want to know what your thoughts are on this one, and I hope you'll enter them down below. And let's be kind with each other, folks, as we talk and share our opinions. Some people think the kid deserves a second chance. Frankly, I think he needs to sit in prison for the rest of his life. Let's watch as I talk with Julie about what the judge is facing now in this decision.
If I were the judge, I know what I would do. Let me ask my guests what they think the judge is going to do and should do here with Aiden Fucci. Retired police commander Mike King on the program this morning, and trial attorney Jamie White as well. Commander, let me go to you on this one. What do you think the court should do, and what do you think the court will do, please?
I think the court should put this kid in prison for the rest of his life. While the parents may say that there's something to save there, maybe just the fact that he gets to live is saving him to some degree. But this family deserves that the court takes this serious enough to say, no, you've taken a life, you've given a life now, because you're going to spend yours behind bars. I can't imagine what kind of a sleepless night the judge had after that compelling testimony yesterday. And you and I, Julie, have talked so many times about victim advocacy and victim rights.
Yes.
These people deserved that moment in time. And boy, did they ever let the judge and the world know what this impacted them with.
You're right, Commander. They seized that moment, caught the nation's attention. So much love going out to the Bailey family. Everybody on their feet now as His Honor is taking the bench. Everybody standing up to show respect for the judge who's going to be delivering that sentence in a matter of moments. Let's listen in together live.
Well, there you go, folks. The judge has come out, and it's time for the sentencing. The question, is he going to get life in prison, or is he going to get a reduced sentence where he can, after 25 years or so, be let out on his own and try to recapture some of life? Again, think about this. 114 stab wounds on this child. And I'm grateful that the judge calls Tristyn Bailey a child, because she is. I'm also glad that Aiden Fucci was tried as an adult. As you watch his callous response during this, I think you're going to have some interesting emotion. So again, let's be kind with each other as we share it.
And Mr. Fucci is also present. We are here today to conclude the sentencing hearing that began on Tuesday of this week. Before I get started, are there any matters that we need to address at this time from the state?
No, Your Honor.
Anything else from the defense?
No, sir.
I did receive some filings as of yesterday. I did review all of those filings. There were about 200 pages of deposition transcript. I reviewed as much of that as possible. I did look for portions of those depositions that I believe were related to this testimony that was received earlier in the week. So I have reviewed all of those filings that were filed yesterday. Before we begin, there is, I think, one matter that I need to address, and that is Ms. Peoples. As far as the determination, I think that has to be made a factual finding as to whether or not your client actually killed Tristyn Bailey. That is typically a finding that would be made by a jury. However, because there was not a jury trial, factual finding could not be made by the jury. And I just want to make sure that there's a stipulation and agreement that the court can make that factual finding based upon the testimony and evidence that was presented during the sentencing hearing. Is that all correct?
that the court is relying on the evidence as presented in the sentencing hearing
And
for that
yes,
factual finding.
for the court to make the factual finding. You're waiving your right to have a jury make that factual finding.
Yes, by entering the plea, Your Honor. Yes.
All right. Based on the evidence that was presented during the sentencing hearing, as well as the defendant's plea to the charge of premeditated first-degree murder, the court does find that Aiden Fucci killed Tristyn Bailey, which now makes the range of possible sentences for Mr. Fucci a minimum of 40 years in prison up to life in prison. Before I begin to address the statutory factors that the court must consider under 921.1401, let me address the Bailey family, as well as the friends who are here today and who have also been here throughout these proceedings. The loss in which you have clearly suffered is unimaginable. The court was certainly moved by the words and the victim impact statements that were presented earlier this week. I have been through these types of proceedings numerous times. Sometimes family members hope or expect that whatever the sentence is, that somehow or another that's going to heal or provide closure. And I just want to warn you that it's not. It's not how it works. No matter what sentence this court imposes today, it cannot heal you. I cannot bring her back. I cannot provide a closure to this. It may close a chapter of this, but it will not close this for you. You still have a lot of healing to do. And I certainly am not going to take the place of any of your counselors or therapists. But my advice to you is simply this. Understand that the healing process takes time, and you have to move through the stages, and you have to allow each other to move through the stages at your own pace. Comfort each other, but understand that some of you may reach different phases of this healing process sooner than others. Your daughter and your sister are obviously, her body is no longer present on this earth. However, her spirit lives on through each and every one of you. From what this court can tell, she was quite a energetic, happy child. Some of you testified to the fact that when you learned of her death, that part of you died as well. And what I would suggest is that you fill that void with her spirit and her life that certainly lives on through each and every one of you. Allow Bailey Sunday Fun Days to return to your home. Allow laughter to return to your home, because in depriving yourselves of that, frankly, you're continuing, it would continue to victimize Tristyn, because that's not what she would want. She would want that happiness and the laughter to return, and the joking between her siblings. That's what she would truly want. You have to try to let go of some of the anger that you still feel. I think that's a big part of this process for you. Mr. Bailey, I want to address something that you mentioned, and that was the process of these court proceedings. I know it's been a long 22 months for your family as well as for this community. Justice at times can move a little bit slowly for those who are thrust into it. For those of us who practice it and live it and work it every day, I assure you that there are constitutional safeguards that are in place in this country, and they're there for a very important reason. And sometimes that takes time to work through that process. And that can be frustrating, it can be agonizing at times. But we strive to make sure that we get things right the first time and that we do things the proper way. More comments, and I appreciated the patience that your family and the community has shown to the court system. These attorneys have worked diligently. They have had, on both sides, they have, this is not their only case, sadly. This is the only courtroom in all of St. Johns County with over 300,000 people who now live in this community. We have one felony courtroom. So every felony, every murder, it takes place in this courtroom. And these attorneys are assigned to cases throughout this circuit. I trust and I believe that they have done a diligent job in this case. And again, I recognize that it can certainly take some time, and I appreciate the patience that you've shown, and I hope that you understand the necessity in making sure that things are done the proper way. Pursuant to section 921.1401, the court, in determining whether a life imprisonment or a term of years equal to life imprisonment is an appropriate sentence, the court must consider the following factors. A, the nature and circumstances of the offense committed by the defendant. B, the effect of the crime on the victim's family and on the community. C, the defendant's age, maturity, intellectual capacity, and mental and emotional health at the time of the offense. D, the defendant's background, including his or her family, home, community, environment. E, the effect, if any, of immaturity, impetuosity, or failure to appreciate the risks and consequences on the defendant's participation in the offense. F, the extent of the defendant's participation in the offense. G, the effect, if any, of familial pressure or peer pressure on the defendant's actions. H, the nature and extent of the defendant's prior criminal history. I, the effect, if any, of characteristics attributable to the defendant's youth on the defendant's judgment. And J, the possibility of rehabilitating the defendant. I have considered all of the evidence that has been presented for the during this week. The testimony that was presented, the victim impact statements, the evidence that was submitted, the filings, and I have analyzed each and every one of those factors as well as any other factors that may be relevant to these proceedings in order to determine an appropriate sentence for this case. The statute requires the court to make specific findings on the record, which is what I will now do. I'm going to begin with factor C, the defendant's age, maturity, intellectual capacity, and mental and emotional health at the time of the offense. This defendant was 14 years old when this act was committed. It is well established, and this court accepts fully that an individual's brain is not fully developed until they reach sometime in their 20s. There is no question to the science behind that. This court recognizes it, accepts it. The court finds that the defendant himself was of average maturity for his age. Based on the testimony that was presented, there were comments about that he was of average maturity, that some of his friends looked upon him as even more mature than the average 14-year-old. He did have a learning disability. His grades suffered as a result. He struggled in school. Resources were put into place to assist him, which he did respond to. The Dean of Students testified about his work with Mr. Fucci, and that there were some things that were done to assist him. He did have some discipline issues at school, but he had a good rapport with that dean, seemed to have a good plan in place. The court has heard the testimony and received some testimony about his emotional health, which kind of segues into the next factor, which is the defendant's background, including his or her family home and community environment. The defendant had a fairly normal home environment. He had two parents who were very involved in his life. The testimony from the grandmother was that his father never missed time sharing, his mother never missed time sharing. I want to comment on the grandmother who testified, who came into this courtroom and testified. That took a lot of courage. That was not easy for her, but it did show in this court that he had a good, stable home environment. While there had been some discussion about, from his girlfriend, that she felt as though maybe there were some things that were going on at home based on all of the testimony and evidence. This court does not find that he suffered from any type of physical or emotional abuse. It does not appear that there was any significant alcohol or drug abuse inside the home. Additionally, the court reviewed the letters that were submitted by his mother and his father, in particular the letter from the father. The court was also moved by, indicated that there was a strong father-son relationship.
Well, hey folks, it's Mike from Profiling Evil, and I wanted to take a minute and tell you about our affiliate, Truthfinder. It's a company that I've been using for a couple of years to research cases and individuals. Now, Truthfinder uses publicly available information, but it brings it together in a way that provides answers quickly and concisely. You can use Truthfinder to check out your new babysitter, or maybe that new love in your life, or just to find somebody you haven't seen for an awfully long time. Truthfinder provides these comprehensive background reports, telephone reports, email reports, and even location information. So when you go in and examine the information in their search results, you're going to find personal information, contact information, and places where your target has lived, not only historically, but currently. Now, all this can seem really overwhelming and maybe a little invasive to you. So I want to make sure you understand all of the information is publicly available information. Truthfinder just has an algorithm that brings it all together in a way that makes it a whole lot easier to access. Now, Truthfinder is an affiliate, which means we get a tiny commission when you sign up. It's about enough to buy a Diet Dr. Pepper, frankly. But I want you to know that I use it every single day, and I hope that you'll take a moment and sign up with them. I've given you a discount code, and it's down in the link below, so make sure you grab it. EVIL10. And remember, you can cancel this thing at any time. Now, I hope you'll give them a try, but before you do, let's just jump back into today's discussion.
I'm going to skip factor E for just a moment and move to factor F, the extent of the defendant's participation in this offense. This court does find that the defendant was the sole participant in this offense. He was 100% responsible for this murder. This court does not believe that there was any encouragement or enticement from anyone else to get him to commit this crime. As to factor G, the effect, if any, of familial pressure or peer pressure on the defendant's actions, the court received no evidence that would suggest that there was any familial or peer pressure on the defendant's actions in this case. The nature, factor H, the nature and extent of the defendant's prior criminal history. This defendant has no prior criminal history. The court did receive, and there had been some discussion about whether or not the court could consider any prior or post-bad acts. I want to make it very clear that the only consideration that this court is giving to any of the information that it received related to any prior acts in school or fights or any of the statements or acts that occurred after his arrest while he was incarcerated were received and considered solely for the purpose of analyzing the factors in this statute. It in no way, shape, or form does this court has this court considered those matters in order to enhance his sentence. It is simply to apply them and apply those issues to these particular factors. The effect, if any, of characteristics attributable to the defendant's youth on the defendant's judgment. I've already considered his youth. I don't find that there were any other characteristics of his youth that really played a part in this crime. J, the possibility of rehabilitating the defendant. I would say that the defendant has shown some ability to modify his behavior that was shown in school through the Dean of Students. However, as Dr. Pritchard noted, this crime is extraordinary. His behavior was so unusual compared to individuals his age that there is a poor prognosis for rehabilitation. Let me move to factor B, the effect of the crime on the victim's family and on the community. The effect of this crime that is had on the victim's family and on the community is significant. There is no greater loss than the loss of one's own child. The nature and circumstances of her death have caused an even greater trauma on her loved ones. Her siblings, parents, and extended family members all provided compelling victim impact statements relating their personal struggles with coping with her death. It has caused them deep and emotional and mental health problems. They are no longer able to function as the family they once were. It has also had a tremendous impact and effect on this community. This court has reviewed all of the letters that were submitted by her friends, teachers, coaches, and others. Approximately 150 letters were received. I have read all of them, and all of them strike a similar chord. This was a devastating crime. It was devastating to the children of this community. It materially changed an entire community. Some of the letters indicated and discussed children who were teenage children who could not sleep in their beds alone and had to sleep in between their parents for fear of what happened in this case. One of the letters I read mentioned the exhaustion of any mental health resources. The supply was in such need that the need was so great that the supply of mental health resources, there was an insufficient number of counselors. Individuals had to wait weeks or even months before they could get in to see a grief counselor. I would submit that this case is probably the most difficult and shocking case that this county in St. Johns County has dealt with. In the 20 years that I have been, or 16 years that I have been practicing law, and the 30 years that I have lived and worked in this, all of Northeast Florida, this case is one of only a very small few that had this level and this type of impact on the community. This court gives this factor great weight. As to the last two remaining factors, the effect, if any, of immaturity, impetuosity, or failure to appreciate the risks and consequences of the defendant's participation in the offense, and the effect of the crime, and the nature and circumstances of the offense committed by the defendant. These factors are somewhat combined. 114 stab wounds, 49 defensive wounds, 35 wounds to the head and neck, 29 to the back and shoulder, and 6 fatal wounds. This court has reviewed and seen more than its fair share of autopsy photos. The autopsy photos in this particular case were particularly difficult. The 49 defensive wounds indicate that Tristyn Bailey was conscious, that she was aware, and that she was doing everything she could to fend off this attack. She suffered a painful, horrifying death from someone that she trusted. Her screams were most likely stifled by her own suffocating lungs. He lured her into a secluded place in the woods near his home, a person that she trusted, and he led her there under false pretenses. There was a heightened level of premeditation in this case. Based on the prior statements that he made to his girlfriend and his friend, he indicated that he was going to kill someone. At which point he determined that it was going to be Tristyn Bailey, I don't know. But there was going to be a victim. He indicated that how he was going to do it, that he would take them into a wooded place, that he would stab them, he would kill them and then run away so that he could keep on killing. He told his best friend that he wanted to kill someone to see what it felt like, and he wanted to watch them bleed out. This particular crime was committed with the weapon of choice as a knife, which he nicknamed poker. That required a up-close, personal, type of murder that is rare. It's unique. The court accepts that in 2019, of all juvenile arrests, only 7% were violent and only 1% of those were homicides. This crime is clearly an outlier, and it was shocking, and it is shocking to the conscious. This court finds that the defendant's participation in this offense was not the result of immaturity or impetuosity. He understood the risks and consequences of his actions. He previously told his girlfriend that he was going to do this. That clearly shows that he had been planning it. He attempted to cover it up by disposing of the murder weapon and throwing it into a lake. He then attempted to conceal evidence by hiding his shoes and shirt and jeans, taking a shower, stealthily entering his home, and then the actions immediately after with the Snapchat videos in the back of the police car and the story that he made up about pushing her and her hitting her head, which was clearly refuted by the video evidence in this case. All of that shows, and this court finds, that this was not an immature or an impetuous type of crime. It makes it unique. It makes it extraordinary. What is also very troubling is that this crime had no motive. This was not done out of greed. It was not done in retaliation, retribution, or revenge. It was not a crime of passion. It was not a crime that was committed because he felt rejected by her. It was not done in a fit of uncontrollable anger. There was no reason. There was no purpose. It was done for no other reason than to satisfy this defendant's internal desire to feel what it was like to kill someone. It was committed in a cold, calculated, and premeditated manner without any pretense for moral or legal justification, and it was heinous, atrocious, and cruel. This factor and this factor alone makes this case and this defendant more than just unique. It is for this reason and all of the reasons previously stated that leads this court to the conclusion that there is only one appropriate sentence in this case. Mr. Fucci, if you and your attorneys would please rise. Counsel, is there any legal reason why this court cannot impose sentence at this time?
No, sir.
Mr. Fucci, having entered a plea of guilty to the crime of first-degree murder, I adjudicate you guilty of the premeditated first-degree murder of Tristyn Bailey. I sentence you to life in prison. Because of your age, you are eligible for review of the sentence in 25 years. I order the Department of Corrections to notify you when you are eligible to apply for your review hearing. Madam Clerk, if you will please impose the minimum fines and court costs. Mr. Fucci, you have 30 days to appeal the legality of this court's sentence. If you wish to appeal but cannot afford an attorney, one will be appointed for you. You will be taken back to the Duval County Jail and then transported into the Florida State Prison System. We are adjourned.
Well, there you go, folks. What are your thoughts on this one? I mean, did the judge make the right decision in your opinion? I hope you'll put your answers down below, your comments. Take time to subscribe, but take time to respond to each other. I also want to say I hope that you'll share Profiling Evil with your friends. I really appreciate your support. And you know, you can find Profiling Evil on Facebook, Instagram, YouTube, and Twitter. So I hope you're sharing us. I hope you're hitting the subscribe button. I hope you're giving us a thumbs up. And I hope that you all enjoy a nice weekend as the weekend approaches rapidly. From all of us at Profiling Evil, thanks so much. We'll see you soon at the next crime scene.